Hello everyone, it's Mark and welcome back. In this video I want to talk to you about guardianship versus Baker Act. So we get a lot of calls here at Baker Act attorneys from people who are calling and they want me to Baker Act their loved one. And what they're really trying to do is to get their loved one some help, to get them into treatment, to get them to take their medication. And so in theory the Baker Act can do that, but so can the guardianship. But the big difference between the two of those is that when it comes to the Baker Act, it's the state of Florida taking custody of your loved one and the state of Florida making decisions for your loved one. And what that means is if you go ahead and Baker Act your loved one, one of two things are probably going to happen. First of all, they're probably going to be held up to 72 hours and then they're going to get released, which doesn't help them at all. Or the state of Florida is going to keep them and potentially keep them up to 6 months, which probably doesn't help them either, because that's probably not what you were intending. What you were trying to do was to get your loved one help. You were trying to make sure that you had control of the situation, as opposed to the state having control of the situation. So, as I've said in many videos before, the Baker Act is not a treatment statute, okay, and it shouldn't be treated as such. It is designed and to only be used in emergency circumstances, and when it's used appropriately, it's a very, very useful tool. And I always tell folks, if it's an emergency, you should call 911. And you should ask law enforcement to come down to your residence or wherever the location is and let them make the determination as to whether or not your loved one meets criteria. Now, look, you can go to the courthouse and file this thing yourself, but again, you're going to deal with the whole issue of 72 hours versus them getting locked up for 6 months. And so I tell families that call us, if you're looking to get your loved one help, the appropriate relief is to file for guardianship. What does that do? Well, it gives you the ability to step into your loved one's shoes. So if they're over 18, they get to make decisions about their medical care, their financial well-being, where they live, who they spend time with, their ability to travel, all these things. And so, obviously if someone has a substance use or mental health disorder, perhaps they're not making decisions that you and I would consider objectively rational and probably not very good for them. And so if you want to, in effect, turn that clock back, turn the time back to when they were under 18 and you could make decisions for them, you're going to need to file for guardianship. Now in the middle of this, and not to confuse you, if somebody is Baker Acted because law enforcement made a decision to Baker Act them, or perhaps an emergency room doctor made a decision to Baker Act them, you can still file for guardianship, and you should, because if you want to prevent the state from taking custody of your loved one and keeping them, then you need to let the court know that you're willing to do that. And courts typically like to defer to the families. But if you don't take action, then at some point the state's just going to take them from you, and they'll do the job that potentially you could have done or should be doing. And so that's the big difference. State is taking control with the Baker Act, and with the guardianship, you're going to take control. And it's entirely up to you which one of those options works best for you. So with that said, thanks for tuning in. See you in the next video. Bye-bye.